Judge Kim, this is Janet Farmer. My camera is not allowing me to appear on screen. It says there's a connection failure, so I will be present. Hopefully,
Okay.
the camera will start working.
All right. Well, thank you for letting me know. Okay, so Mr. Alvarado, this is a detention hearing. You've been here for 10 days, so we have to review your case, decide what to do. Keep you in custody or to release you. If I keep you in custody, you have to see a judge every 10 days thereafter. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing can be used against you at any other court setting, or cannot be used against you at any other type of court setting. You have a right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. You are 17 years old in, wow, about 2 weeks. And let's see. Your history of this department started when you were 14 with an assault case, evading arrest, theft of property from $750 to $2,500, theft of property from $2,500 to $30,000, and evading arrest with a vehicle, burglary of a habitation, unauthorized use of motor vehicle, burglary of a habitation. A week later, another burglary of a habitation. At this point, you're 15 years old, 16. Burglary of a habitation, which you got probation for in January of this year, and you were put on probation. And then, so in April, see, Fort Worth PD got a warrant for you. They were dispatched for a shooting call, found an unresponsive male with a gunshot wound. But this is the one where there was a basketball game. It got an argument, and then everyone left. And there's a car that was by. People trying to pull the victim away from the car after a gun came out. He was shot, and witness put you as a driver, and witness also put a gun in your hand. So, all right. Well, so you were charged with the offense of murder. All right, I remember this one. So, yeah, Mr. Alvarado, so there's probable cause for the case of murder. I'm not saying that you did it. I'm just saying that there's enough here to substantiate that if it was true, that was in fact a murder. And then you're also level 3 in our detention facility, so you're causing problems. Why is he level 3? You know,
Your Honor, he got into a physical altercation with another client in detention. I don't have any details as to how or why it happened, other than they both got in a physical altercation yesterday.
All right, Mr. Youngblood here?
I did not see him on there, Your Honor.
All right, Ms. Jacobson. Pointing on, are you level 3, Ms. Jacobson?
I am not level 3, Your Honor, but I believe the client is.
Well, no, level 3 on our appointment list.
I am not level 3.
Right.
Your Honor, I'm on the appointment list. I will step in for Mr. Youngblood. I don't need any compensation from the county at all. I'm happy to assist today in this detention hearing. Attorney Trent Lofton.
All right, so, all right. All right, so Mr. Alvarado, you were on probation for burglary of a habitation, and now somebody puts a gun in your hand where somebody got shot and died, and your behavior level is level 3. I'm just letting you know that I'm not going to release you under these terms. I find that you're a danger to yourself and to others. Also let you know that, is this one, Ms. Farmer, do you know, is the state, I heard the state may be seeking certification on this one?
Yes, Your Honor, we are. I believe we've already filed for certification.
Okay, all right. So here's my thing on that. If you want to relay the message to your chief or assistant chief is, he's been here for 118 days. It's pretty late to, it's pretty late in the game to file for certification. All right, so it's going to move pretty quick. So if y'all need any of the studies done or investigations done, tell Mr. Youngblood, then y'all need to move on that quickly, because I'm inclined to just go ahead and set it for adjudication dispo, just because it's, I would think certification should have been filed probably about 100 days ago. All right.
Okay. Yes, sir, Your Honor. I'll relay that message.
All right, thank you. I'm not upset. I'm just saying it's not fair to Mr. Alvarado to wait this long before we go forward. So, Mr. Youngblood, I don't know if you're familiar with that. I know you just popped in. Mr. Lofton's been covering for you in the meantime. But your client's level 3. He was on probation when this alleged offense of murder happened. And the state is filed to seek certification. So
yeah, I heard that last night.
okay. I'm not happy that it's taken almost 120 days to file certification. So if it doesn't move quick, we'll just go forward on the juvenile case without the certification unless they can get their ducks in a row.
Understood.
Okay. All right.
Mr. Alvarado was going to, I'm saying this for his benefit, was going to call me later in the week and go over the evidence in his case, and I encourage him to do that. It's getting more and more important.
Sure. No, I understand. But at this point, level 3, I'm not going to release him.
I understand.
Okay.
Is his mom on the Zoom deal this time?
Is mom here?
Yes,
I think she's in the parents' courtroom.
Okay. Mom, can you hear all this? I can't see you.
Yes, I can.
Oh, there you are. Okay. I apologize, Judge. But since I just popped in, is there anything you want to tell the judge?
Not at this moment.
Okay.
All right. Victor, as a final note, you're level 3. That means you're causing all kinds of problems back there. I'm going to let you know, once you turn 17, I have the absolute discretion of holding you downtown. So if you can't be an example for the other kids back in our juvenile detention facility on how to behave, then I will just have you housed downtown by the sheriff. So if you want to have your own pod, if you want to eat the better food, less restrictive environment, then you need to earn your keep here. Otherwise, you can just go to Gen Pop downtown or Lon Evans, depending on where the sheriff classifies you. Okay, yes, Mr. Youngblood?
Also want to remind my client, this is just law, not about you personally, but the state is allowed to use how you behave in the juvenile detention center as evidence in a punishment trial if they can find you guilty of something. Do you understand that?
Yes, sir.
Okay. And if you're asking for probation or something, the judge could use evidence like that to decide that he does not want to do probation. So I don't know what's going on, and we can talk about it when you call me, but you need to figure out how to behave back there without problems. Lots and lots of other people can do it. I know you can, right?
Yes, sir.
Are you having a particular problem with another detention person?
No, sir.
Are you having a problem with a staff member?
No, sir.
Okay, well then, I don't want to say anything further, but it'd be pretty obvious that you've got the problem, right?
Yes, sir.
Okay, thank you, Your Honor.
Thank you. Mr. Alvarado, your attorney makes a very good point. Everything in your detention can be used against you at the certification hearing as well as at the trial itself. Okay? All right. Thank you, Mr. Alvarado. Next, we have Angel or Angel De Leon.
Your Honor, I have both parents here today, and they're only Spanish speaking, so I can help translate.
Okay. Thank you.
Judge, the next 3 are on a different camera, so they're on a different unit. Give them a second. Mr. Reyes is helping up there on HPod.
Thank you. All right, are you Angel De Leon?
Yes, sir.
Okay, is it Angel or Angel?
Angel.
Angel. All right. So, Mr. De Leon, I'm Judge Kim. This is the detention hearing. The law says when a child is brought to our detention facility, you have to see a judge within 2 business days and have to make a decision whether to keep you in custody or to release you. By keep you in custody, the law says you have to see a judge every 10 days while you're here. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so Mr. De Leon, you have never been to our department before. You're 14 years old. And let's see, Richland Hills said on August 4th at about 8:30, they were dispatched to Baker and Handley Elderville. That's right down the street. about kids shooting fireworks. Once the police got there, they made contact with 3 subjects. After speaking with the 3, they admitted to shooting fireworks. Jones admitted to having fireworks in his backpack. When they did a probable cause search, Angel admitted to having a firearm in his waistband. They found a 9mm pistol with 4 rounds in the magazine, but none in the chamber. And when Angel was asked his first name, he gave the name as Alex Gabriel. So he was placed under arrest for unlawfully carrying a weapon, failure to ID, and brought to our detention facility. So that was just yesterday. All right, so Angel, you have never been here before, which is a good thing. All right.
Your Honor, I
Yes?
do want to let you know that he does have a misdemeanor pending with Dallas County for assault caused bodily injury, and he's scheduled for plea and dispo on the 26th of August. The family is from Dallas County.
Oh, okay. Is Mom, okay, so can you ask Mom what he was doing here in Tarrant County?
Señora, ¿qué es lo que estaba haciendo su hijo aquí en el condado de Tarrant?
Él lo agarraron en Richardson, creo.
Sí, es el mismo condado. She's saying that they picked him up in Richland Hills. And I'm telling her that it's the same county.
Yeah, so how did he end up in Richland Hills?
¿Cómo es que llegó el niño aquí a Richland Hills?
No sé realmente.
She doesn't know. He leaves.
Oh, does he leave very often?
¿Lo hace seguido?
Sí.
Yes, he does.
Does she know where the gun came from?
¿Sabe de dónde recogió la pistola?
No, no.
It wasn't mine.
Okay, sir, you have the right to be silent, so just my advice is probably to use that right and not say anything. This is not your trial. This is not whether you did it or not. This is simply about whether I should detain you or not. Okay, I look at different things like whether you can come back to court when you need to, whether you're a danger to yourself, to others, what your history is. These are the factors I look at. It's just simply about whether I keep you here while your case is pending or I release you while your case is pending. Right? So, okay, so Mom, when we asked if she knew where the gun came from, what did she say?
She said she didn't know.
How often does he walk out the house or run away?
¿Qué seguido se va de la casa?
Todos los días.
Every day.
Oh, okay. Well, that makes it easy. All right, so Angel, then this kind of makes it easier for you. You're not following the rules at home, right? You're disrespecting your parents by leaving whenever you want every day. And it gives me great concern. I'll let you know, I know you're from Dallas, but for me, it's a really big deal when kids have guns. That's where I draw the line. I'm not okay with it. It's not acceptable. So at this point, I'm going to detain you, right? Mostly because you had a gun. We don't know where the gun came from. We don't even know how you got to Tarrant County. The fact that you're running away gives me a lot of concern as well. So I'm going to detain you. We're going to see what your behavior is like here. If your behavior is up, then that opens the door to the idea of releasing you. But if you cannot get to one outstanding, then you're just going to stay here till the case is done. Okay? Especially because there's an underlying gun in this offense. All right. Do you have any questions for me?
No, sir.
All right. Ms. Rojas, when did you say he was set for adjudication dispo in Dallas?
On the 26th of August.
Okay. Yeah, you may want to call your counterpart in August. If his behavior level is not better, I mean, I guess they can come and get him and bring him back. But
so you're ordering that he be detained until he reaches level 1 outstanding?
No, I'm ordering him detained. I'm not going to make a decision on that one.
Okay.
And so if his behavior is as bad as it probably seems like it will be, based on what the parents are saying, he may be here past the 26th.
Okay.
Judge, can I ask some questions real quick?
Sure.
Sorry. Dallas County triggered something. So Ms. Rojas, does he have conditions of pre-adjudication conditions in Dallas County?
I'm not sure.
I guess what I'm asking is, Judge, I'll do some behind the scenes work for our next detention hearing. So I'll have all kinds of answers from Dallas County too, okay?
Okay. No, that sounds good.
All right, thank you.
Thank you. All right, thank you.
Thank you. Señora, si me puede esperar en el lobby, va a ser detenido el niño, ¿ok? Como le expliqué. Gracias.
You can change that back from Trent Lofton to Edwin. Ford Fowler. And Mr. Jacobson, I believe this is yours. Do we have parents here for Mr. Fowler?
We do, Your Honor.
I'm sorry, Your Honor. I believe this is Mr. Lofton's case.
Oh. Oh, yes, Mr. Lofton.
Yes, sir.
There you go. All right, so Mr. Fowler, this is a detention hearing. The purpose of this hearing is to make a decision whether to keep you in custody or release you. This is not a trial. Okay. After I make the decision, if I detain you here, then the law says you have to see a judge every 10 days while you're in our facility to make a decision whether or not to keep you in custody. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. In the interim period, Mr. Lofton has been appointed as your attorney until we make the determination on your indigency. All right, so Mr. Fowler, let's see, you are 15 years old. You were previously here last year in December for possession of a controlled substance in a drug-free zone, felony level offense. And we give you a drug test yesterday and you're positive for weed. And it looks like the December case was penalty group 2, so it's probably a vape cartridge or THC oil. So you got deferred prosecution, which evidently didn't work. All right, so let's see. Fort Worth PD says on July 9th at about 7 o'clock, they were dispatched for a robbery call. The victim said he received Snapchat messages from Caleb, who lives nearby, invited the victim to hang out at the AutoZone on beach where Caleb was hanging out with another friend. The victim arrived to find Caleb with Ford Fowler, somebody the victim knew from high school where all three were in the same grade. Also present with another male with tattoos on his arms and face. Face tattoos. Victim said that after he got there, Caleb said, "Yo, sorry, man, but I'm taking your shit." And Ford and Grant walked closer to him. He formed a half circle who has back towards the rear wall of the AutoZone. One of them pulled a black pocket knife, unfolded it, held it down by his side. Victim said he turned his body, began to back away, saw an opening and ran, leaving the phone and the bike, and went home. So when the officer was conducting the interview with the victim, another officer searched the area, found a person matching the description of the third suspect, questioned him, said he was hanging out with Caleb and two other people he didn't know. So he met Caleb and one of his males near Kroger, which is the same shopping center as the AutoZone. Three went to the house of a fourth male. They all hung out, and they all parted ways. He said he denied anything was taking place that required the police. He went back to AutoZone, located the bicycle cell phone behind the business, which was returned to the victim. So all right. A couple weeks later, police interviewed Caleb, said he'd known the victim since junior high, told him over Snapchat to hang out behind the AutoZone. When he was there, told the victim to give him whatever illegal stuff he had on him so he could throw it away. Oh, he's a Boy Scout. It said the victim must have interpreted that he was attempting to rob him because he ran away, leaving his bicycle and phone behind. He told him to come get his bike and phone. He said, no, they can have it. They walked off, leaving the bicycle and phone behind. When Caleb was asked about the other people, he said he would not name the other people, and he doesn't remember a knife. Caleb said that looking back, it couldn't seem like he was robbing him. So there's a photo lineup. And Ford Fowler was arrested at home without incident. All right, so your mom and dad?
Yes.
Yes.
Okay. You know he's still smoking weed?
We try.
Okay. Well, that didn't answer. Okay, hold on a second. That didn't answer my question. Did you know he was still smoking weed?
He leaves the house and I suspect that he does, but I don't have firsthand knowledge that he does.
All right, Dad, come on. All right, I'm a dad too. All right, so we're just talking here. I'm not here to beat you up. I understand as parents we do the best that we can, and as they get older, we lose more and more control. It's not like they're 4 years old anymore. We can just pick them up by an arm, right? But for me, as a parent, and it seems like you're both involved. Are y'all still together?
Yes.
Yes.
Okay, all right. So you're both involved. You're both here today and missing work or whatever it may be. But, you know, we gave him a drug test and he's positive. I'm just kind of throwing out there if you knew he was positive or not. I understand 14 years old or 15, to a degree, he'll do what he wants to do. But I want to make sure that y'all understand that the decisions that he's making.
Yes, he do.
Okay. You know this Caleb person?
We know the name.
Huh?
Actually, yes, I've met Caleb. Yes.
Okay.
I don't know Caleb very well, but I do know of Caleb.
You know him well enough that you're comfortable with your son hanging out with him?
No.
Well, you don't know him well enough or you're not comfortable?
Both.
Okay, fair enough, Dad.
He's been told many, many times. So
Yes. Well, I am confident, Mom, that if Ford was listening to you and Dad, the three of us would never have met. I mean, that's just kind of the way life works. Are you worried about him using other drugs?
Yes.
Oh, you are? Okay. Do you have anything like, do you have any confirmation of that, or is that just kind of like the parent gut feeling?
Well, I'm just afraid one thing leads to another.
Right. You want us to give him a hair test?
I mean, the hair test.
Yeah,
what's
hair follicle test. It tells us the full spectrum of any drugs he's using. Like, I'm kind of inclined now. Would y'all like to know?
if-
Sure.
Okay.
We would strenuously object, but we get it.
Yeah, I mean, I understand. This is where there's that divergence between the adult and the juvenile system. So,
I understand, Your Honor.
yeah. All right. So this is what I'm gonna do. Well, for this is where I'm at, and it really doesn't matter what your parents had told me. The conversation we had, I like to have this conversation with parents because there's something about your mom and dad I really like right now. Now, this being said, we're talking about there's enough to establish there was an aggravated robbery. If the things that the police are saying that the victims said are true, that would be what's called probable cause. So my concern is when we're talking about violent crimes like this, especially with you bringing drugs to school in the past and currently using drugs after the deferred prosecution, that also gives me, and then Caleb saying, give me anything illegal that you have. It seems like y'all are involved in the possession or the distribution of illegal substances. I don't believe Caleb really wanted to throw it away on behalf of this victim. So it just gives me a lot of concern, the behavior that you're in, the people you're hanging out with, and the decisions that you're making. So I'm going to detain you for now. We're going to go ahead and get a hair follicle test and see what else you're using. And then from there, I'll make a decision. A lot of it's going to be based on your behavior level here in our detention facility. Now, Mr. Ford, do you understand what the law of parties is? Ford? Mr. Fowler?
No, I don't understand what that is.
In Texas, there's something called law of parties. And what that means is when two or more people decide that they're going to either plan, commit, or benefit from a crime together, they are all separately and individually guilty of the same crime. Okay, so here's the example. Let's say me and my bailiff here in this courtroom decide, along with your probation officer, or Mr. Lofton, your attorney, that we're going to commit a bank robbery. And my bailiff says, hey, I used to work security in that bank, and so I know when they have cash, a lot of cash in the drawers. Mr. Lofton and I go and we rob the bank. The bailiff is gone. He's at home watching football on TV. We go into the bank, and well, what happens is Mr. Lofton goes in with a note. Doesn't even have a gun. I'm the getaway driver. Well, this old security guard there gets a little freaked out, starts shooting the gun, and hits a customer and kills the customer. And then Mr. Lofton runs out and we drive away. Okay. So what happens is that customer died during a felony offense, so it becomes a capital murder, eligible for the death penalty. Mr. Lofton, who didn't even have a gun, didn't pull the trigger, well, he could get the death penalty. I was the getaway driver. I helped commit the crime. I could get the death penalty. And my bailiff, who wasn't even there, since he was part of the planning, could get the death penalty. So you understand how in Texas, any person who participates in a crime or benefits or plans it in any way is guilty of the crime itself, all right? So that is why, even though you may not have had the knife, you may not have said anything, it seems to me that you were part of this group that was part of this aggravated robbery. And so under that reason, that law, I'm gonna go ahead and detain you for now, okay? You understand? All right, so keep your behavior level up and we can talk about you getting out later. Right now, I think it's Mr. Bell.
Yes, sir.
Okay, there we are. Yeah, if we can go and let's order a hair follicle test.
Absolutely.
Parents are having concern. I think that's going to help in deciding what kind of services he may need if there is probation. All right.
Okay. Thank you, Your Honor.
All right. Thank you.
You have to excuse, Your Honor.
Yes, Mr. Lofton. Good to see you again.
Good seeing you, sir. Have a good morning, everybody.
Caleb Riddle. I'm sorry. Everyone's got the COVID-19 haircut lately.
Yeah, those are my people. Yeah, my brother.
All right. So, all right, detention. Hey, Mr. Riddle, do you mind sitting up straight?
Sir. Yes, sir.
Thank you. All right, so this is a detention hearing. The law says when a child is brought to our detention facility, you have to see a judge within 2 days and I have to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. Mr. Graham is appointed as your attorney for this hearing. Is James here?
Don't speak, Your Honor.
All right, so Ms. Jacobson, I'm going to appoint you. It actually doesn't matter what level you are for detention hearings. So, I'm going to appoint you to be here to assist Mr. Riddle if he needs it. So, all right, so Caleb, you're 14 years old. You've never been here at a detention facility before.
Yes, sir.
And okay, this is the companion case to Fowler. Like July 9th, about 7 o'clock, there's a robbery. Caleb asked the guy to come out behind the auto zone and said, the victim said, he said, sorry, but I'm going to have to take your shit. They circled the victim. One person pulled out a knife and held it by his side. So the victim saw an opening, ran off, left his bike and phone behind. So Caleb was brought to the location by his mom. He said that no one robbed the victim, but he did tell the victim to give him whatever illegal stuff he had so he could throw it away. And the victim must have interpreted as he was attempting to rob him. And that's right. The Boy Scout good deed for the day. Give me your drugs so I can throw it away for you. All right, so the victim's phone and bike were located behind the auto zone. And both were returned to him. The two other suspects were identified, one adult, another juvenile. The victim reported that he was 75% sure it was Grant who was holding the knife. So the rest is a companion. All right, so Mr. Riddle, I'm going to let you know that you understand what the law of parties is?
No, sir. Can you elaborate?
Like, I can tell you right now, Caleb. Well, let's do it. Mom, Dad, is he always a smartass?
Unfortunately, for the past few years, yes.
Oh, I'm so sorry.
Mr. Riddle,
Your Honor,
at this
thank
point,
you.
you have the right to remain silent. I hope you have the ability. So anyway, yeah, I've already just listened to you for a little bit. I already know enough that I'm going to detain you. And so I'm going to find you a danger to yourself or others. All right. And because of this, also, Ms. Rodriguez, you're here. Let's go ahead and give him a hair follicle test as well.
Yes, Your Honor.
Decision if he's making poor decisions or not. Mom, Dad, do you have concerns about his drug use?
Yes.
Okay. Yeah, I do too at this point. Is his attitude stuck at home too?
Yes.
Okay. Yeah, this is, here's the thing. One of the things I consider before I'll release a kid is what their behavior level is back here. If he keeps up this attitude here, he's not going to get out while this case is pending. He's going to have to fix his attitude. And if I let him go, he will have to maintain that good attitude in your home as well. So just let you know in the future, if he does manage to fix his attitude and show he can make good decisions and I release him, then I'm expecting you to let us know if he regresses and keeps up the attitude back at home, because we'll just bring him back here. All right. And so anyways, but yeah, so at this point, I'm detaining you. I'm going to let you know, Mr. Riddle, I don't know. There's also a fourth person. It seems like you're kind of the leader of this little group, is that retaliation is a felony level offense, and that is going to be based on the level of offense that you're looking at. So if this is in fact aggravated robbery is a first degree felony, you could be doing, in theory, if they seek determinate sentence approval, that means a grand jury approves this, you could be looking at 40 years in prison over this, right? Now, if you do have other people that are influencing or trying to interfere with witnesses, you're also looking at another 40-year sentence per incident that's happening. So I want to encourage you that your conversations with other people are wholesome, for lack of a better term, and that you don't get yourself potentially into trouble, especially if you didn't even do the robbery. It'd be a shame for you to pick up a 40-year tampering with witness charge for a robbery that you didn't even commit. Right? So just kind of putting that out there, Mr. Riddle, but we'll be watching your behavior level. We see you in 10 days. Thank you, sir. All right, so at this point, yes, Mr. Riddle, did you have a question?
Can I see my parents?
What do you mean, can you see your, like in person?
Or like talk to them? I haven't talked to them at all.
Well, if you're talking to them the same way that you've been talking to me, I don't know that they want to talk to you. I mean, your attitude toward them really is a bad attitude. Like, I'll be honest, if I was your parent, the way you just talked to your mom a couple of minutes ago, I wouldn't want to talk to you. That doesn't surprise me. Look, be the kind of person that be the kind of kid that you would want your kid to be. But you have to understand, your parents love you and they're still there for you. They're here in this courtroom or this Zoom session because they care about you. But if you think that they're stuck with you, they're not. They can walk away. And at a certain point, if you make it difficult enough for them, they will walk away. This is also not only a juvenile court, but a CPS court. I can't tell you the number of parents I've seen that they say, I can't deal with my kid anymore. They've gotten too big, their attitude's too bad, and they just walk away and the kid goes into foster care. If that's the direction that you want, well, I mean, you're on the right path for that. But your parents can call you, but right now, because of COVID-19, we're not allowing any kind of in-person visit. So you will be able to talk to your parents at certain intervals on the phone for a period of time, and your attorney certainly can talk to you whenever they need to. Okay. Did you have any other questions?
Is there any way I could get released sooner?
I'm sorry, any way you can get released what?
Sooner.
So here's the problem. When you ask a lawyer, is there any way? Hypothetically, yes, there's all kinds of ways it's possible. But I'm gonna let you know now that it started out me trying to have an earnest conversation with you. You became real snarky with me. And so I need to make sure that you prove to me, not only do you get your behavior level to level 1.0, but that you maintain it, that I see it's not an act that you're doing, try to work the system so you go home quick, but you actually understand how to follow the rules. Yes, sir.
Sir, I promise there was no disrespect meant by anything I said.
So here's the thing, Mr. Riddle. The number one rule to when you dug yourself into a hole is you stop digging, right? So the fact that you were snarky with me and sarcastic, and now you're lying to me, you're digging yourself deeper into this hole. My advice to you is to stop digging. There is no situation in life, Caleb, that you can't make it worse, right? And you are right now, you're making it worse. One of my biggest pet peeves as a judge is when people lie to me, right? I don't lie to people, and I expect them not to lie to me. So you can be sure I'm certainly taking notes down now that you're willing not only to be sarcastic with the court, but also to lie to the judge. Now, remember earlier when I told you have the right to remain silent, I advise you to use it. I hope you have the ability. The last couple statements you made have only made your situation worse. It's probably better for you to exercise your right to remain silent. It hasn't helped you. Waiving that right has not helped you so far today. All right, so Mom, Dad, are we going through this? But, you know, I'm very consistent. This is who I am day in, day out. If you watch these hearings, I'm not treating Caleb any differently than any other kid. Right? I know it probably affects you more because it is your son, but there's certain things I just don't tolerate. Okay? All right, well, thank you very much. And now, my portion of this detention hearing is, yes, Mr. Riddle.
Can I have a word with my parents?
Well, again, I told you they can call you, right? But I'm not going to stop this court proceeding because you want to stop it and have a word with your parents, right? This is kind of the problem with our snowflake generation, is they feel like the world revolves around them, and we have to stop everything just to make sure that you feel more comfortable. That's not the way it works. Being at Kimbo is not a comfortable experience. It's not meant to be. It's not meant to be uncomfortable, but it's not meant to be a pleasant experience. This is the incentive you have to behave and get yourself out of here. But it's not going to get out of here if you think the world revolves around you. Okay? All right, so I've concluded my portion. Judge Porter is going to take over and conclude with the rest of the hearings for today. Thank you, everyone.
Thank you, Judge Kim. Right.
Okay, have a W.
Judge Porter, it's Frank.
Hello, how are you, Mr. Adler?
Hey, good morning, Judge. We don't need a detention hearing. We're going to waive.
And he is at level 1A, so you are allowed to do that.
Thank you, Judge.
Do you need to speak with him briefly, just so that we have his affirmative agreement?
I was with him this weekend in detention.
All right.
We have a plan. Thank you, Judge.
All right. Thank you, Ms. Guerrero.
Thank you.
And then there were 3. All right. You, Mr. Estrada?
Yes, sir.
All right, Mr. Estrada. My name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you have to see a judge first within the first 2 business days, and then thereafter every 10 business days. And so this is a 10-day detention hearing to determine if you should be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there is something you do want to say, please, please do not blurt it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. And I will create a private internet chat room for you and your attorney. Now, Ms. Mills is not here today. Is that correct?
Judge, if I may, no, Ms. Mills is actually en route back from Austin, and she did let me know as well as the clerk's office that she was going to be unavailable to attend this hearing.
All right, Ms. Jacobson, are you available for this?
Yes, Your Honor.
Thank you so much. All right. So, Mr. Estrada, if there's something you want to say, move your hand back and forth like this. That'll get my attention. It'll also get Ms. Jacobson's attention. And I'm appointing Ms. Jacobson as your attorney for purposes of this hearing. I'll create a private internet chat room for you and Ms. Jacobson to talk about what you want to say. That way she can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. Ms. Young, what brings Mr. Estrada back to court today?
Judge, actually, Angel has already appeared before this court, and he's already had his adjudication, motion to modify and dispo on the 14th of July, at which time the court did order him to residential placement at Brookhaven. It was anticipated that he would have a leave date of the 23rd, and then at that particular placement site, they had a COVID case that they needed to resolve, so it delayed his leaving. Then they rescheduled it for the 3rd, and we anticipated that he would leave on that date. Now it has been delayed 1 more week.
Oh, no. All right. Now, Ms. Young, am I correct that if I were to release Mr. Estrada today, before he could go into placement, he would really have to come back to detention for 2 more weeks to wait out a quarantine period before he goes to Brookhaven?
That is correct, Judge.
Oh. So, Mr. Estrada, if I release you today, you're going to have to come back to detention and spend 2 more weeks before we can ever get you to Brookhaven. And that would actually delay you getting to go. So you understand why it would be a bad idea for me to release you? You understand that?
Yes, sir.
All right. Also, I want to note, Ms. Young, what level is Mr. Estrada at in the back?
He is 2. Outstanding.
Mr. Estrada, you've been back there for more than 2 months. That's plenty of time for you to get to level 1-0, correct?
Yes, sir.
So what do you think I'm going to ask you to do?
To get to level 1.
I want you to tell me 2 things you're going to do to make that happen before you leave next week for placement.
Do the right things.
Which means what?
Do not lose any points. And just
And how are you losing points?
by acting up.
Well, acting up, you're also not following instructions like you're supposed to, are you?
Yes, sir.
So you got to do a better job of that, right?
Yes, sir.
Here's why I want you to get to level 1-0 before you leave. I want you to leave here ready to start off at Brookhaven on the best foot forward, okay?
Yes, sir.
Because if you make that decision right here, right now, today, to follow the rules, and you commit to doing it back in detention, then once you get to Brookhaven, you've already engaged in that mindset. You're already ready to follow the rules at Brookhaven, to commit to treatment, and that will make Brookhaven a whole lot easier for you, okay? Because I want Brookhaven to be a positive experience for you. But if you're fighting the rules, if you're trying to break them, if you're trying to skirt the rules, Brookhaven's going to be a lot longer than it needs to be. Does that make sense?
Yes, sir.
And I want it to be a good, positive experience that you learn from, not a bad, negative experience that draws out for a whole lot longer than it should. All right? Are you willing to do that for me?
Yes, sir.
All right. As for today, I got to order that you be detained, all right?
Yes, sir.
Thank you, Mr. Estrada. Good luck. I want this to work for you.
All right, thank you.
Thank you, Ms. Jacobson.
Thank you, Anna.
Thank you, Judge.
Thank you, Ms. Young. All right. I'm going to try not to butcher your name. I know I did it badly last time. Mr. Slongen, did I get close?
Close, yeah.
Okay. How about I call you Matthew? Is that a little less stressful?
Yes, sir.
All right. Matthew, this is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. Do you see your attorney on the screen, Ms. Jacobson?
Yes, ma'am. Oh, yes, sir. Sorry.
All right. If there's something you want to say, please do not blurt it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. It'll also get Ms. Jacobson's attention. I'll create a private internet chat room for the two of y'all to talk about what you want to say. That way she can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. Ms. Paxton, what brings Matthew back to court today?
Your Honor, this is his 10-day detention hearing. He was referred on June 8th for the offense of continuous violence against the family. This was a series of 3 separate incidents of assault, bodily injury, family member. We had, in this case, he assaulted grandfather. And then we had a case from April 11th where he struck his grandfather. And then we also had a case from December of 2019 where he shoved his grandfather. So they, this one is a felony because of the other 2 cases.
He's at level 1-0 and has been since July 24th?
Yes.
All right. Ms. Jacobson, what are your thoughts?
Your Honor, last time we had a detention hearing, you had asked me to look into other placement options. I have been in contact with the mother to look into any family or friends who might be available placements for Matthew so that he wouldn't have to go to a more formal placement or to TJJD. Unfortunately, I haven't been able to get any names or numbers from her. Most frustrating for me is that we do not know who Matthew's father is. I've been attempting to get Matthew's father's name from his mother to see if he would be a viable placement for Matthew. And she has not been able to give me the name or number. I believe she knows it because when I spoke with her on July 23rd, she told me that she would give me the number. But when I called her the other day, she refused to give me a name or number. And so that is one of my concerns, that there might be a family placement that we just don't have access to because the mother won't give us the information.
All right, Mom, now that Ms. Jacobson is finished, I'll give you a chance, but let's don't talk over each other. That's rude, and we need to be nice to each other, okay? Mom?
I said I could try, but she had got on the phone with me telling me that it was prison or somewhere else. None of my family member wants to take him because he has had violent outbursts toward almost every family member. So they feel that him being here and being able to get into hopefully a placement that might hopefully work, they are more for that than others. She gave me the impression that it was prison or something else. Me trying to find his dad and give that information was like the last chance. But me both giving him the option for prison or his dad is me giving up on him. And I don't want to give up on him. I want him to be able to try to get the help that he needs, and sending him somewhere where that person has had a lot of legal issues as well, and kind of the same situations that's been going on, and he doesn't know him, is very disheartening and gives me a lot of anxiety type issues. And I don't have his information. I don't keep track of him. I do have his name, but I have nothing else.
Well, would you be willing to give that name to Ms. Jacobson?
No, because if we have that option to try to get Matthew to help, I want that option to get him help, not to just give up on him.
Okay. Ms. Jacobson, we seem to be in an impasse in getting any time.
Sorry.
I'm sorry, I didn't mean to be talking while you're interrupting. Go ahead. Go ahead.
I'm sorry. I remembered she said that I wouldn't give other names and numbers. I told her I would give her names and numbers, but she's, no one's willing to take him in if he's able to get help here.
Okay.
And she can take
Mom, do you understand that you are unilaterally making the decision of what options are available to Matthew's attorney? You're actually impeding the attorney's ability to talk to anybody. Maybe Ms. Jacobson has a way of persuasion that you don't have. And maybe Ms. Jacobson has investigators who can help her to find a placement short of TJJD that will help your son. But you have to help her explore all possible avenues.
And I've told her I'd give her the name and numbers of my family, but she doesn't want that. So she can talk to them. She didn't want that. She sat there and argued with me on the phone. And because I told her I didn't have the name and number for him. And she started going off on me on the 3rd.
Well, you've told the court that you do have the name of the father. You've also told the court that you refused to provide that name to Ms. Jacobson, correct?
Yes, sir. But he refused to let me put him on the birth certificate.
That's a separate issue. That's apples and rutabagas, okay? Ms. Jacobson, we seem to be in an impasse in getting Mom to provide you with any help in being able to effectively represent her son.
Did you tell him?
So, Ms. Jacobson, what is your recommendation? What steps does the court need to take?
Your Honor, I haven't had this issue happen before. To be fair, I did ask for any contact information for anybody who'd be willing to take Matthew. Initially, when I did talk to Mom asking for Dad's number, that was on July 23rd, where there were no placement options, informal placement options other than TJJD. Since then, my understanding is that I believe on July 30th, there was a placement option as far as Granbury, but I would like to explore any other family options, because if we could get Matthew with a family member, that would be much better than going to a formal placement in Granbury.
Mom, Texas law requires us to go through what we call progressive steps in helping kids with their needs, whether it's behavioral or mental health or any number of needs. And we need to go through progressive steps. And one of those steps is we try to keep kids with their direct family or immediate family or even related family whenever absolutely possible. Texas law favors that because we think kids need to be with their families. Mom, do you understand?
Yes, I understand, and I do agree that he needs to, but we haven't been able to help him.
Okay.
I'm just stuck.
Well, you're stuck because you're forcing the system to skip steps. You're forced by your own refusal to help Ms. Jacobson in any shape, form, or fashion. You're forcing us to skip steps and jump from 0 to the worst possible option. Matthew, you have the right to remain silent. Please, there's nothing you can say right now that's going to help.
No, I want to talk to my attorney, sir.
Okay, well, we'll get that in just a minute. Ms. Jacobson, at this point, I'm going to appoint you both as the attorney and the guardian ad litem for Matthew.
I apologize.
Yes, ma'am, go ahead.
Is it possible to get a court order to have Mom tell us who the father is, so at least we can look into his criminal and CPS history to see if he's an option?
I'm going to allow you to approach the court with a written motion to that effect. Obviously, Mom, I'm taking it that you don't want Matthew to come home with you today.
Like I said, he can. He, you know, what's going to happen the next time? What's going to happen the next time? You know, we've tried our hardest to get him to want to go by rules and obey. He only will do it if it benefits him. And yeah, if I take him home today, what's going to happen if he gets another call?
All right, I'm going to take a
It's just, I don't want to take him home. The next call will throw him into prison without this option.
Sounds like.
Okay. Mom, I'm going to tell you right now that once Ms. Jacobson presents me with the motion, I will grant it. And I will order that you disclose the name to Ms. Jacobson. I will also further order that you disclose the names, phone numbers, and addresses of all immediate family members with any relation, within the second degree of relation to Matthew.
And I've told her I'd give her
Let me finish before you interrupt. If you do not obey that order, I will issue, and you will have 7 calendar days to provide that information to Ms. Jacobson. If you do not supply that information within 7 calendar days, I will issue a writ of attachment, and you will be taken to the Tarrant County Jail and held there on criminal contempt. And you will be held there until you decide to provide that information to Ms. Jacobson. And at that point, you could be held there for 5 minutes or 5 years.
I'm almost willing to do that.
I am sorry that it has had to come to this, but I'm not going to allow you to impede Ms. Jacobson's attempts to fulfill her obligations under the law to your son. Do I make myself clear?
Yes, sir.
All right. Now, you wanted to say something.
Matthew, I will call you after this hearing, so don't say anything right now.
Well, it's kind of important to.
Well, Matthew, wait for Ms. Jacobson's phone call, okay? That's really, there's nothing you can offer at this time that's going to help, okay?
It's not an offer.
I understand, but Ms. Jacobson, it appears we're at an impasse despite Matthew being level 1-0 since July 24th. I don't believe that Mom is willing to take him home. I have no choice but to order that he be detained. I'm not convinced that that is in his best interest, but I think based on the circumstances, we don't have a choice here. I expect Mom to provide that information to you within 7 calendar days. If she does not, then I will sign the writ of attachment. All right.
Understood, Your Honor. Thank you.
Your Honor, my grandfather.
Matthew, I'm going to call you afterwards.
I know, but
Yeah, grandfather, you need to say something?
I would like to point out that Wendy wants the best for Matthew, but when she was pregnant with the child, not only did the father not let her put his name on the birth certificate, he asked her to abort the child. So us as a family aborted him as anything to do with Matthew. There are mental problems in his father's family. That's why we don't want to go there.
And I appreciate that.
Okay,
but we have to allow Ms. Jacobson to explore the option. Now, her investigation may absolutely confirm that the dad is completely unfit. I recognize that's a possibility, maybe a probability, but we can't close the door to her, okay?
Okay.
Yes, sir.
I do like the idea of her investigating his criminal record and all, but she really needs to pay attention to his father's criminal record.
I have full faith in Ms. Jacobson.
Okay, now when she called Wendy and talked to her about Wendy having to do something with Matthew or him going to prison, maybe she didn't know about the placements then, but she does now. Those are good things. So.
All right, we cannot close off doors without at least investigating them, okay? All right, Matthew, that's going to be the order of court. Thank you.
Thank you.
Ms. Jacobson, if you'll provide me with that order today, I'll sign it today.
Yes, Your Honor.
Thank you. All right, are you Mr. Villa?
Yes, sir.
All right, Mr. Villa, this is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says that when you're brought into detention, you have to see a judge within 48 hours and thereafter every 10 days. So this is a 10-day detention hearing. You have the right to remain silent and not say anything at all. If there is something you want to say, please do not blurt it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. That'll also get your attorney's attention. Ms. Uzawihe, do you see her on the screen?
Yes, sir.
All right. I'll create a private internet chat room for you and Ms. Uzawihe to talk about what you want to say. That way she can advise you on whether or not you really should say it. Excuse me. Does that make sense?
Yes, sir.
All right. Now, Mr. Jennings, Mr. Villa is level 1-0 in the back and has been since July 25th.
Yes, Your Honor.
All right. What brings him to court today?
Your Honor, this is quite convoluted. I'll try to be as brief as I can, but also being as thorough. He was originally placed on probation on this term of probation on January 14th by you for theft from a person. Approximately 3 weeks later, he was arrested in Dallas County for unauthorized use of a motor vehicle. We transported him over here. He was released by Judge Kim on the electronic monitor on February 6th. On February 21st, he cut that monitor off and left home without permission. On March 3rd, he was taken into custody in Grand Prairie and transported to our department. On March 4th, you detained him at that time. He had a 10-day detention hearing on March 18th. He was again detained at that time. On April 1st, he appeared before you again. You released him on the monitor. On April 25th, he cut the monitor off and left home without permission. On April 29th, he was returned home by the police department. They, after we were able to submit a progress report requesting that the directive be rescinded due to our detention center refusing to accept Ernesto into the detention center at that time due to a medical condition that he has where he had to be transported to JPS. JPS then sent him to Cook's Children's. He was there for a few days. He was allowed to return home. The DTA, like I said, was rescinded. On June 25th, Ernesto had left home without permission. He was high, cussing and threatening his mother. Officers appeared, but did not want, were not able to take him into custody at that time. We submitted another progress report on the 25th requesting the DTA. On June 26th, you did issue that. On July 21st, Ernesto was located in Arlington. He was transported to our detention center. Due to the illegal substances he was taking, he was not treating his medical condition. He ended up going to JPS. At that point in time, I was asked to submit another progress report to you to see if you would wish to have that DTA rescinded. At that time, you declined to do that, so we did. Once JPS cleared him, we had Fort Worth PD transport him up to our detention center. He appeared before Judge Kim on July 22nd. Hearing all of this at that time, Judge Kim ordered that I submit a CPS report immediately. I did submit that report, as Judge Kim, I believe, was hoping that CPS would be able to place Ernesto in a secure facility to address his medical and substance issues. CPS is still investigating that, but I don't believe they're moving as fast as and as thorough as we would hope. On July 29th, he appeared before Judge Terry for a motion modify disposition hearing. That hearing was passed to request a psychological and a psychiatric evaluation to be completed. We have both of those scheduled. The psychiatric evaluation should be completed this week. He is scheduled for a psychological evaluation on August 16th. That report is due back by the 24th. I am scheduling a resource staffing on the 26th. Once we have that report in hand, to see if there's any options that we have available to offer to the court when he does go to court on September 4th.
All right. Does he have a parent or guardian in the Zoom meeting today?
Yes, Your Honor. It's Lydia Hernandez, and her she is labeled as Galaxy S10 Plus.
All right. Ms. Uzawihe.
Yes, Your Honor. Can you hear me?
What are your thoughts? Yes, ma'am.
Okay, so Your Honor, so that's the history that Officer Jennings has narrated. My client has diabetes. That's one of the concerns, with keeping him in the detention. So he wants to go home. He has done well. I mean, I haven't been able to speak to mom, since yesterday or today, so I'm not sure what her position is. I think I would ask the judge to find out from her directly. But what my client wants to do is that he want to go home. He said that he will not, if you would give him another chance, he will be able to come to the, to go to the probation department or go to the office whenever he's asked to come for whatever reason. But he said that even if you have to let him home with EM, that he is going to abide by any condition that is attached to it.
Uzawihe, did you hear Mr. Jennings' report about how many times Mr. Villa has removed his electronic monitor?
Yes, Your Honor, I did, and all those things are true. I mean, I'm not playing it down. Yes, they are true. But again, Your Honor, let me say this. I am more of an advocate here than a lawyer. So I'm just, but honestly, I want to leave it to the discretion of the court, for the fact that we're talking about his health, we're talking about other things. And then the fact that these are all these things scheduled, the psychological evaluation, the psychiatric evaluation, and all these things going on, the staffing and all that. So, yeah.
All right. Ms. Hernandez, if you can hear me, could you please stop moving around? Ms. Hernandez. All right.
Esto.
It appears that Ms. Hernandez is having trouble getting her phone to work properly. And so she is actually distracting in this hearing. Okay.
You're not, would you, is it okay? I just to ask the courts, is that okay with the courts? Would that please the court if I like call her like right away? Like,
no, it's not. I'll be honest with you. It's not going to change my decisions here today.
All right.
Mr. Villa, you have been level 1-0 since July 25th. That weighs very heavily in your favor because that's a long time to maintain level 1-0. And your attorney makes very, very good points. However, the last 3 times we have let you go, including me, I let you go not once, but twice. What happened? The EM got cut off and you ran away. So, yeah. Suddenly all that good stuff that you've been doing, that 10 days, or actually more than 10 days at this point, the scales are greatly outweighed now because you cut off your EM not once, not twice, at least 3 times. Okay. Plus, wait. You don't want to say anything. Okay. Plus, one of those times was like less than a month after I put you on probation. The scales are tilted way, way against you at this point. Here's how you tilt those scales back in your favor. You got to maintain level 1-0 for a whole lot longer. And the longer you do, slowly those scales get back to equal, and then it just slightly tilts in your favor. Once they're equal and they slightly tilt in your favor, then I'm more inclined to believe that you're not going to go out and commit new offenses. You're not going to cut an EM, okay? But because this is your 3rd, 4th, 5th time at the rodeo, I'm not inclined to believe that yet. Does that make sense?
Yes, sir.
And you understand why, right?
Yes, sir.
So what do I need you to do?
To keep my level 1.
Yeah. All right. I'm not convinced yet that if I were to let you go, and I really do want to let you go, but you haven't earned it yet. Okay. At this point, you got to earn it. Makes sense? All right. So that's going to be the order of the court. You'll have another hearing in 2 weeks. Okay.
Yes, Your Honor.
All right. Thank you, Ms. Uzawihe. Thank you,
All right.
Mr.
Thank
Jennings.
you, Your Honor.
Thank you.
All right.
Thank you so much.
All right.
Thanks,
Thanks, everyone. I believe that concludes. Yes, ma'am.
Oh, I just said thank you, Judge.
Oh, okay. I believe we're done for the day. So thank you, everybody.
Thank you, Anna.
Thank you, Anna.
Thank you, Ms. Jacobson.